Hi, everyone. Welcome to episode 155 of the Immigration Lawyers Podcast. We have a really cool podcast and episode today. I'm having a discussion about federal litigation, two major cases that popped up this week. And it's going to be a regular segment with Kevin Gregg, fellow immigration attorney, partner at Kurzban firm. And also the firm has more names than I don't mean disrespect. I can't remember all of them, but he also has a wonderful podcast, which I recommend everyone subscribe to. It's called Immigration Review. And he does the work for you of analyzing recent federal court decisions that affect all our cases. And I asked him, and he kindly accepted to come and talk about some major cases, two in particular that affect us, one being the case that struck down the fee increase that was going to happen and the wild decision that it is because of the consequences of it, as well as another decision that looked like a regular CNMI case, CNMI, as we all know. As practitioners reading that every once in a while, wondering what is that about. Well, has wide consequences for a lot of other cases too. So I want to thank Kevin for coming on and doing that, and definitely listen to the whole thing because it's going to help your practice. And I'm in there adding my commentary in the middle of all of it, the political stuff, little commentary here and there. Before we start, I want to remind listeners, especially those that are new to the immigration practice or thinking of getting into it, my course on marriage, green card cases, consular processing, adjustment status, I-130s, is starting on November 3rd, Tuesday, for 4 to 6 weeks to cover all the basics of a marriage green card case. And I think it's going to help a lot of people start their own practices or add a practice area that they may not have had. That's going to start again on November 3rd. It's a Tuesday. It'll be an hour or two a day for once a week for 4 to 6 weeks to cover everything. It'll give you a running start. Just email me at info@Immigration Lawyers Toolbox for information about that. Again, that's info@ImmigrationLawyersToolbox.com. And also, I want to thank our sponsor, DocketWise. DocketWise is a great form software I've been using for a long time. It's part of my practice, and I definitely recommend everyone else use that too because, as I spoke about last time, the ease, how smooth it is, but also as part of that smoothness, how easy it is to adopt. There's no learning, complicated languages of code or something like that. There's no learning different ways to use the software. It's very intuitive and really easy to adapt. So in particular, if you're transferring from one software to another, you don't have to go through that headache, that steep learning curve to learn how to use it. You and your team, paralegals, assistants, attorneys, everyone could quickly adjust to it. I think that's fantastic. I think that's one of the main things that hinders people from moving softwares or moving programs because they know how much of a headache it is to transfer the understanding of the software over to another. And I could say for myself, and that was one of the reasons I just didn't want to learn any softwares after going through a couple of these online systems I just didn't want to go with the headache. But, a friend told me about it. I tried it out, and I definitely recommend it. And as a benefit to listeners, you can get 10% off the annual plan. The annual plan is already discounted from the monthly, and add another 10% to that. So there's a lot of savings. Just go to DocketWise.com/immigration-lawyers-podcast. And again, that's DocketWise.com/immigration-lawyers-podcast. And you'll be able to get an annual subscription and really take your team to the next level, yourself, your practice, your team, to be able to get things done faster, smoother, and more reliably. They got a great system over there. We'll talk more about them in the future. But I guess with that, let's get it started.
Welcome to the Immigration Lawyers Podcast, a part of the Immigration Lawyers Toolbox, an education and marketing publication for the immigration law community that includes legal updates, interviews, discussions, education and CLE material, and more. Note that the information here is for general education only and not intended as individual legal advice. The laws change frequently, so you should consult with an attorney about your specific case. For more information, please visit immigrationlawyerstoolbox.com.
Hi, everyone. I hope you're doing good. We have a really interesting episode, and it's not really our typical podcast episode. It's more of a federal litigation update. It's something I always wanted to do. I had a portion that I did last year for this, but it was hard to keep up. But we got really lucky. Kevin Gregg, a partner at the Kurzban and Kurzban law firm, I don't know what the full name is, but everyone knows Kurzban, started a podcast of his own, which I recommend everyone go and listen to. It's called Immigration Review. Is that correct?
That's right.
And so Kevin Gregg is the podcaster and immigration lawyer who has a lot of experience in litigation in this space and removal and all sorts of cases that you can imagine. and he does a great job. And we reached out, we did an interview, and you can find our interview. That was like maybe a month ago or a couple weeks ago, definitely a few episodes back, to listen to that, to get to know his background. We do 10 questions with him. And I said, could you come on the show regularly so we have a routine where you just go over one or two of the top cases that people really should be aware of in the federal litigation space that could help their practices. And, this month we have two, because as you all are getting the emails and constant updates from the federal litigation and from USCIS, there's massive things happening it seems like every 2 or 3 hours that affect our caseload. So I want to jump in and have a talk about the two cases that are really, they're really important to our practice. So Greg, Kevin, thank you so much for coming on. Do people call you Greg all the time because you have a last name as the first name?
Oh yeah, you don't even know the half of it. I think there's a phrase, "Never trust a man with two first names," which it's quite frank, it's true, to be honest. I worked for judges for years, and there was a judge I worked for 2 years, and on my way out, he wrote me an email calling me Greg. I mean, I knew this judge very well. I would have been like, "Judge, like, we know each other. Like, we've had dinner together." But so be it. The worst is hotels, actually. They ask you for your first name. They ask you for your last name. You say Greg. They say, "No, sir. Your last name, please."
Yeah.
Anyway, thanks, John. I really, likewise to you. I really appreciate everything you're doing. I think you're doing great stuff, and I think it's just really helpful for the immigration bar. It's how I found you. It is Kurzban, Tetzeli, and Pratt. I don't want Helena Tetzeli and John Pratt to be upset with us, but everybody, of course, knows it is Ira and his nephew Jed, who has the malpractice side. So thanks for having me on. I'm excited to do this with you once a month. On the podcast, I don't usually discuss district court injunctions, especially in the era of Trump, because it's just so much all the time. I'd go crazy. But this week, it's Thursday, October 1st, we're doing this. It's been a bit of a slow week out of the circuits this week. And because I'm going to be on your show, I took a look at the Immigrant Legal Resource Center et al. V. Wolf et al. Out of the Northern District of California, published on September 29th, 2020. And then also after that, I'll talk about the Torres case out of the Ninth Circuit that came out last week.
And Marcia, people got to listen to the Torres case, because I just skimmed over it when I saw it was CNMI, as we all probably do when we see CNMI, but there's much more into it that's interesting.
I did the same thing. I knew these CNMI cases were important, but like it's very niche. I'm like, I don't really care. And then I read it, I'm like, oh shit. But we'll get to that in a bit, because Immigrant Legal Resource Center, it's really applicable to everybody. And it's applicable because, as you're probably seeing on your emails, it's about all the fees, the fee hikes that USCIS was trying to do and did in a final published rule. And so, everything was going to jump. John, you've been kicking it out on your social media. I don't know, 40%, 80%. I mean, things were I think NATS applications were going to triple. So it was just crazy fee hikes. And this Immigrant Legal Resource Center v. Wolf et al. Is one of 3 cases, I believe, that were challenging those fee hikes. This one was brought by Ayla and Sidley Austin. I got to just hand it to Jesse Bless out of Ayla, who, he's been around for a year or two. He came from oil. And he seems like he's killing it. And thank God that oil decided to put some funds into a litigation department, because now is the time. And I think they're doing really good work and partnering with the firms to assist them. And so Jesse and Sidley Austin.
What? Putting money behind that is, you mean Ayla or oil?
No, well, Jesse came from oil. Okay. He was at oil for many years, and then I think he left during the Trump administration, and then Ayla hired him to head up the the new litigation department at Ayla, and they've gone full steam ahead. And so
I should have him on the show. I didn't realize. I had no idea about these facts, so I'll try to reach out to him.
Yeah. I mean, I don't know Jesse. I think our paths may have crossed, but he seems like he's thank God we got somebody, and it looks like Jesse's a great somebody to be doing it. And they got this win right here. They've gotten some other wins this year and last year as well. And so this one they got a preliminary injunction in the Northern District of California that's nationwide, preventing USCIS from implementing its fee hike that was going to go into effect tomorrow, October 2nd. It was Judge White in the Northern District of California, and I don't like to talk about the politics of the judges, but I mean, I don't know, when it is a Bush appointee who does the injunction, I think it's important to note it. These are not just political individuals. This is their bipartisan judges being appointed by various presidents issuing these decisions.
On a note, sorry to keep interrupting, but Trump has been
Please do.
the most successful probably he's been in the appointment of judges, and look at the Supreme Court he's doing. But one thing is important to note that despite the 200 or so judges he's appointed federally, when it comes to immigration, it's really hard to pin down on a fact basis how people are going to move on certain things. So there's some hope there that even though the judges are Trump administration judges appointees, it could go either way sometimes.
I think that's right. I mean, just look no further than Justice Gorsuch and some of his immigration rulings, because, and now we're getting off on a tangent, but I love it. Because when you're talking about immigration, you're talking about agency case law, and if we're just talking about firm politics and such, the Federalist Society, Heritage Foundation type supported judges don't really like agencies like the EPA and other agencies getting into the aspect of what they believe should be the province of Congress and actually acting like many legislatures. And so a lot of the case law that they would support is about reining in agency action. Mm-hmm. But that is just as applicable to immigration cases as it is to any other agency. EOIR, DHS, those are agencies. And so if you are true to that belief, I think that's one of the reasons you see some of these judges issuing decisions that end up favorable to the immigration bar, because they're treating them like an agency that they are, an executive agency.
There was that decision. We have Chevron deference, but there's another kind of deference that I learned from that case last year that passed.
Or our deference, and that was the Wilkie v. Kaiser decision too, right? Right, and that's coming out of a straight Federalist Society, Heritage Foundation type view of the law, that you shouldn't allow agencies to have all this deference. So it's kind of an interesting little quirk. But I work for judges. I think they're all really smart. Even if you don't agree with them, I don't like to label them based on their political appointees, but there's no doubt that the judges being appointed now are coming from, a lot of them, the Federalist Society, Heritage Foundation lists. So they do definitely, it appears, have a certain judicial philosophy. We'll see how it goes. But anyway, this one is not by one of those judges, by a W. Bush appointee. I looked him up just for the hell of it. And he issued a preliminary injunction barring USCIS from implementing this new rule. And the new rule on the fee hikes went through the notice and comment process that is required under formal rulemaking when the agency is going to significantly change its position, as it has done with the fee increase. And during the notice and comment rulemaking, there is just that notice to the parties and participants that this new rule is going to change, and then an opportunity to comment. And that's comment from the public, including the immigration bar. And to be honest with you, I mean, AILA's been urging individuals to comment on all these changes from DHS and EOIR, and I've never done it because I just think I'm wasting my time. There's no way it's going to affect the Trump administration. But in this case, Judge White found one of the reasons that he believed the plaintiffs were likely to win and therefore deserving of a preliminary injunction on the substance of their Administrative Procedures Act was because it appeared that DHS had completely ignored the comments showing what the rule on the fee effect would have on certain individuals and immigrants and other aspects. And so you're writing those comments not necessarily for the agency, at least in the era of Trump, I suppose, but for the federal judge who's going to see that APA challenge. And so that definitely got me thinking. The quote is, DHS seems to, quote, ignore information presented during the notice and comment period that contradicts DHS's belief about the price elasticity of demand, end quote. So, you're writing to the judge. I guess I should have thought of that. But so I thought that was pretty interesting. But even more interesting, and I don't know, John, if he looks like you're, even more interesting to me, though, because the substance of the APA claim, and they brought Administrative Procedure Act claims, which is one of the biggest tools that you can bring to challenge immigration actions in district court. But that was the third reason Judge White believed that plaintiffs were likely to succeed on their claim. The first two reasons were because Judge White found that Acting Secretary McAllen and Acting Secretary Wolf were unlawfully in their positions as acting DHS secretaries at the time the rules became final and implemented. And the Judge White found that they were unlawfully in their positions for two independent reasons. And it's pretty wonky, and I'm no expert on all of these like government statutes and DHS executive orders of succession, but of succession, not secession.
Which secession may happen soon.
Right, secession might happen soon. We'll see what happens. Just a joke. But I mean, to me, that's pretty big. I don't think Judge White is the first to say that these individuals at USCIS were unlawfully in their position at the time a rule was implemented. I'm not sure, but like,
it wasn't another judge, I think East Coast, Maryland, or something like that, that said something that to first. So it's for the asylum case where they said they're only going to apply to the asylum change, some chain rule. They didn't let it go broader than that.
Right. I mean, this is big. I mean, and especially if there's other ones. These are now judges. To me, I'm no expert on this, but it would seem that everything McAllen and Wolf touched in immigration is unlawful and subject to dispute in district court now because they were never lawfully in their position.
Let's talk about that. That could be one of the biggest things that ever happens to the Republic, even because the DHS rule is so big and undoing all the actions and immigration, the amount of numbers of immigration decisions and things that come out from DHS is so much. But then add that everything else, this has to revert back. I mean, it's just going to be. I think it would actually demolish the immigration system even more than this, because how do you walk back all this stuff?
I mean, if anything, it gives you an argument to make in any federal court. I mean, I don't think you have that issue at EOIR. No, they're not Senate confirmed anyway, and EOIR is under DOJ, and there's, other than the Whitaker stuff, I mean, there's no problem there. But with DHS, I mean, I think you've got that argument everywhere now that nothing these guys have done is proper. Neither of these guys were Senate confirmed. Wolf wasn't even nominated up until I think last month, and he's certainly not Senate confirmed. Ken Cuccinelli, who I don't think his appointment was material to this case, but he was a defendant, they won't even call him the head of USCIS in the government. His official title is Senior Official Performing the Duties of the Deputy Secretary of DHS and USCIS, which it's just ridiculous to me, right? They can't even call him that because they know they're violating the law with his with putting him in that position. That's very interesting to me.
Cabinet level position like DHS without Senate confirmation, it really destroys the Constitution, puts it upside down, because it's such an important post, and the founders really put this in there. You know, things like state, Department of Justice, these such an important post. DHS essentially is an amalgamation of a lot of these important posts. By having him, just the administration's audacity to put people in these positions without Senate confirmation. Because these people wouldn't go through, if they had Senate confirmation. I mean, Wolf didn't have as much baggage, I think. Probably they might have been able to go through, but go through the process. What are these appointments? But do you think, and this is going to speculating into politics, but we saw with the public charge injunction that was lifted once it got to the circuit review, they quickly undid that. The politics of undoing all these decisions, do you think if the Ninth Circuit panel comes in, which has a lot more conservative judges or that leaning side now than before, do you think it's going to stand? Because let's say even legally, you're 100% was illegal employment, everything should be wrong. And this is going to, again, political science and stuff, but do you think they would be willing to do that because of the consequences of that decision, or the domino effect of it is going to be so crazy and catastrophic to deal with as an agency matter?
Yeah, I mean, short answer is I have no idea, but I'll say it kind of rubs me the wrong way, though, saying, because of the conservative judges of the Ninth Circuit or any circuit might then affirm it. I mean, I don't know when conservative meant embracing an expansive view of executive power in violation of Congress. I mean, that was never the conservative view, or really anyone's view, of the Constitution. So I don't think conservative, and I don't consider myself one, but I don't think conservative means you just support what President Trump wants. And I doubt these Ninth Circuit judges, I hope that's not how they view themselves. And so, I mean, looking at this case, Judge White's relying on at least two statutes, one of which goes back to 1935, about succession of these cabinet officials and what's required. I mean, Congress put in a framework, and you're just interpreting the statute. That seems to me Federalist Society 101, but I guess it does remain to be seen, and it is increasingly political.
Yeah, but I mean, even though it's a net positive for immigration lawyers to undo all the garbage that they put in, it's kind of like just thinking, because we all know how on a day-to-day basis they've been attacking the system. To undo that, it's even overwhelming to me to think about, which would be great actually, because it's so ridiculous. I mean, we have notices that are coming out right now where they want to do voice recordings of affidavit of support joint sponsors and iris scans. We have a new IA-64 policy that's going to come into place. They just listed today, where we need credit reports and all this extra stuff for the sponsor. Those are just the simple kind of stuff. There's much more hardcore things going wrong. I mean, the EOIR stuff, which is a whole different thing. I just want to mention it. Mana Yagani, one of our colleagues in Texas, posted on a Facebook group. They want to force lawyers to reveal how much their clients are paying them before the EOIR. Crazy nonsense, which is, to me, it's blatantly illegal, because that'll give ICE attorneys understanding of how much power the client has to fight. If they see they didn't have to pay much, they'll know they could walk all over a person. Complete injustice right there. But sorry, I had to get off my chest at the mention.
No, it's important. That's kind of what this is. This is why I like talking to you. I mean, I also got a lot to get off my chest. I think we talked about it a little bit last time. It seems, immigrants in America, it seems it is the first testing ground of what can be, encroachment on due process rights, and the first dip your toe into fascism. I mean, I don't think it's an accident they were sending CBP officers into Portland.
Yeah.
And that you can take away all these rights at the border. And you do this to the immigrants, the non-citizens, and not that many people are going to stand up and care, because there's a lot of ways to distinguish them from you. But that's the first step in fascism. I'm not saying it automatically happens, but it's definitely the first step. I think Hannah Arendt would agree. Yeah. You go to the marginalized peoples first, and if you get away with it, you keep creeping. Again, not necessarily going to happen. I don't think it will. I hope it won't. But I think we have to put our foot down at the immigrants, and that's why you and I do what we do.
Yeah. And I like the Hannah Arendt quote. Hannah Arendt, she used the term totalitarianism and the banality of evil about Nazi Germany, and how regular people just found themselves in this position. And when you look at what happened in Oregon, I mean, they have unmarked cars picking up people. It's wild, the things they're doing. Yeah.
And it's CBP.
Yeah.
The FBI wouldn't do it. I don't think it's an accident. Before I get off this case,
police force, I think that the federal government has, their main police force is CBP. It's the biggest organization.
Right. No. I think there's one other interesting quote at the end of this one before I go to Torres, and that's so Judge White honed in on the fact that DHS repeatedly stated it, in quotes, that DHS was stating, quote, "It does not intend to discourage meritorious asylum claims or unduly burden any applicant group of applications or their families," end quote. And so Judge White and the plaintiffs honed in on this fact that DHS kept saying, we're not trying to discourage any meritorious asylum claims with this fee hike. But as Judge White recognized and held, fees aren't supposed to discourage anything. That's not the point of fees. Whether or not you think there should be less asylum applications is up for debate, but fees are only there to cover USCIS operating costs. By considering whether it's meritorious or not in your fee hike analysis, you're violating the APA. You're considering something that Congress didn't intend you to consider. And I thought that was pretty interesting. Judge White held that DHS's purpose to discourage immigration benefits filings, quote, can be reasonably inferred, end quote, from what they were saying. And so good on you, Judge White. Good on you, Jess Bless and Sidley Austin for throwing us a bone here.
But just to be on the conservative side, I'm filing these cases ASAP and new ones just in case the injunction gets lifted. We got to pay a higher fee. We're getting them
Oh,
in.
yeah.
But,
Yeah, I mean, who knows what tomorrow brings. I know there's something big happening with the diversity visa lottery stuff, and I'm just haven't read it. And there, like you said, something's happening every week, it seems.
yeah, the judge said, I just read the tweets from Greg Siskin. There's a 9,000, the judge ordered 9,000 visas to be held
Right.
past the deadline of September 30th. So they're holdovers. And their embassies are playing games, DOS. They're saying only people that are party to the suit could use it, not other people, which is like super garbage.
Right.
But yeah, thank God, these poor people, they win the lottery. They were so excited to come. They put their life, they probably end their life back home, ready to go. And this happens. And we had another decision maybe a couple hours ago, I think, which said the non-immigrant visa, work visa bans was illegal too. And so those COVID-related L1, H1, J1 bans are overdone injunction too. So it's just being an immigration attorney is kind of overwhelming. I kind of get anxiety. It's with all this, like, oh, this happened. To get calls, and it's overwhelming.
Well, that's a great intro into the Torres case. But before I get there, I just want to be clear. Like, personally, I think this whole, ruling immigration by judicial fiat out of all the district courts is crazy. It's making our life insane, and it shouldn't be how it is, but it's become necessary based on how this administration is treating the Immigration and Nationality Act and just basic administrative procedures.
Mm-hmm.
But I mean, ideally, right? You don't want everything going to court, and then one judge says this, and then the agency stuff. I mean, this is nuts.
Crazy.
But it's necessary, I think, at this time, this extraordinary time.
If Congress fails to act, I mean, they passed the bill last night too, and they made pre and processing some good stuff, some bad stuff in there, but no one knew it was necessarily going forward that quickly. They're just throwing stuff at us. And, the representatives don't read this kind of stuff, and they don't know enough about immigration to be able to pass a bill. The Indian immigration bill requires a lot of nuanced understanding and writing. And when you just have something where you say, oh, you passed the bill last night, that there's some people getting screwed in that for sure, especially immigration.
That's nuts. And so in the Torres case, the Ninth Circuit, and I quoted it on my podcast last week, it's just so good, I won't do it again, but the court called the provisions of the INA, they compared it to a morass, a Gordian knot, and King Minos' labyrinth in ancient Crete. That divining its meaning is not for the faint of heart. So I think it's pretty good stuff. I mean, so the Torres case is an en banc Ninth Circuit decision, and I'm pretty sure the Ninth Circuit is unique in that it can go en banc without the full court. Mm-hmm. You just need a quorum. I think they're the only circuit that can do that. But either way, it is the word of the court, and it can only be overturned by the Supreme Court or by another en banc panel. And this was a unanimous decision, which is, I think, is pretty unique on en banc courts because there's so many different judges. Yeah. And just whittled down to the holding, and we talked about it last week on the podcast in more depth. Iwis are those who have entered without admission or inspection or admission, who have entered the U.S., as I read it, can't be charged under 212A7AII for failing to have valid entry documents at the time of admission. That's how I read the holding. That's how a lot of people are reading the holding. I only hedge because, we always have to hedge as attorneys. But to me, that means that all immigration attorneys, and this aligns with a Fifth Circuit decision and an 11th Circuit decision, although I don't think either of them were quite as explicit as this, nor were either of them en banc. But to me, this means whip out your motions to terminate every time DHS charges your client who is Iwi under 212A7, that is an improper charge. That's what the Ninth Circuit en banc court said. That's supported by the Fifth and the 11th. And just a plain reading of the text, which is what the en banc court held, because 212A7AI makes removable non-citizens who don't possess valid immigration documents, quote, at the time of their application for admission, end quote. And the board and the circuits have played around with the concept of admission and what is the time of admission. When you adjust status in the U.S., that is an admission. So admission is a bit fuzzy under immigration law, but
Anytime.
the Ninth Circuit en banc is saying, at the time of their application for admission, and read in context with the other statutes, the panel, the en banc court, said this only means one thing. This means someone outside the United States trying to get in. That is the time of your application for admission. Nothing else is. And so you can't charge them with an A7. And as Ben Winograd noted, and he tweeted at me thanking him for giving me props on his podcast, but he deserves it, and I'll give it to him again. Only A7s, well, not only A7s, but 212A6AI, which is the present without inspection or admission, or present without admission or paroled, 212A6AI are not subject to expedited removal. Only the A7s are. And the Trump administration has very clearly, and they made known, I'm not being political, they made known their intent for DHS to use the expedited removal provisions to the maximum extent of the law. I think you and I talked about it when we talked last month that, geographically, potentially something like 80% of the U.S. population is within the geographical boundaries of who could be deemed applicants for admission and subject to expedited removal. But if they're not removable under A7, which this case is saying they're not anymore, then I don't think they're subjected to expedited removal. And by the way, most of those border places with immigrants are going to be in the Ninth Circuit: Arizona, California, Oregon, Washington, all the border with a lot of immigrants. So that's Ben right there, and I agree with Ben, and that's a big holding to prevent expedited removal.
Big. I mean, talking about the fascism and just the idea of internal checkpoints to catch people who have been here up to 2 years within 200 miles. And that means every major city could have checkpoints to ask for papers. That's just mind-boggling that people aren't in the streets about this. I mean, it's a little more complex to understand. It's immigration. But as if you look at the civil liberties, ACLU kind of angles at it too, it's just crazy. Internal checkpoints, show me your papers. You look a little different. You have an accent. You didn't bring your green card or naturalization certificate with you. You get expedited removal potentially. And we've had cases where ICE picks up people that are citizens and holds them, and for years sometimes, just because the person can't get the paperwork together, or didn't became a citizen as a child but didn't apply for naturalization certificate, so not handy. They're not sophisticated enough to explain all this stuff, or they don't care to listen. So these are really important. Affects everybody. It's like at the core of every American life. These cases are so vital, and we're really kind of lucky and blessed to be practicing an area that's historic, really, what we're going through. They're gonna look back at this time, kind of like when we look at cases, during 100 years ago that were really groundbreaking. This is a crazy time to be practicing.
Yeah, no, I definitely tell myself that on the late nights when I'm freaking out about clients and I have a pit in my stomach before an individual hearing how lucky I am to be doing this. And I do believe that, but man, it does not allow me to sleep well sometimes.
Well, I wanted to mention something about the whole idea of what is a mission and these terms of art that are so messed up. BIA had said for TPS people that they had made some ruling, and we got a great decision on that one. Do you know what circuit it was that made that? Was that night too?
Yeah, I know. I don't think it was. I'd have to look again. There's just so many. That one is ridiculous. I'm sorry. That that issue that if you have left on advance parole with TPS and then come back in with advance parole, you have not been paroled within the meaning of 245A, such that you can adjust status. I mean, what is a parole?
And back to the previous status, even though you had TPS when you left, TPS is temporary protected status, and its name, it's just.
Yeah, I mean, look, the INA has been IRA has been around since and implemented since '97. I mean, how is it the case that only 23 years in? Oh, wait a minute, that's right. Okay, advanced parole doesn't mean parole, such that for 245A purposes, I don't. I don't know how you write that one with a straight face. Just how some of the things that have been issued by USCIS and the board during the Trump administration, I don't think they're being written with a straight face. I think they're being written with policy concerns and not the law in mind, not the text of the law in mind.
Now, just speaking about BI, because Trump placed a lot of people there, and change the number of BIA judges. If it's that easy to mess around, like they're talking about court packing on the Supreme Court, which is a no-no because there's a historic tradition to it. But the BIA is much more flexible. So if a new president comes, they can manipulate the BIA board that easily too. I don't do too much BIA. I don't do any BIA UIR work, so I don't.
Yeah, again, I don't know any of these judges, personally. I can't speak to them, but it certainly seems things that I'm reading and some things that I'm seeing out of the board looks like they're being put there for a reason. And the Trump administration there's just no question they're packing the board. They bought out board members who they didn't like, and then they packed it with many, many, many more board members. And I think that if a Democrat president was doing it, the Republicans would be implementing impeachment proceedings. But because immigration is not something, it's just so wonky and it doesn't rile up the left unless you've got children in cages and you've got visual images of it. But, case law out of the board is just so weird. It doesn't rile up the progressives. It's just gone unnoticed. But the board is packed with Attorney General under Trump appointed BIA members. I don't know. I don't think they're going anywhere. My understanding is IJs and board members get appointed to 10-year terms that get renewed. But, you don't just fire a federal employee, nor should you. And that's what board members are, is federal employees. And so you've expanded the board. They're not retiring anytime soon. They're not that old. I'm worried about what's happening to the board and their judicial philosophy of immigration there under the Trump administration and maybe going forward.
There's a lot we talked about. I just think there's a decision that was made to allow pro se people to have legal help and guidance, but I don't want to get into it. Just all this other stuff, like, oh, this happened. No. It's kind of unbelievable this much is happening. Just keeping on top of it so hard. And that's why I really appreciate you coming on, sharing your expertise and the time you're spending all this to share with our audience. It's so important to keep up on this stuff to give good representation.
Yeah, I appreciate you having me. I'm happy to do it, and it's a lot of fun. Just one more thing on Torres I thought was interesting. It's important for everyone because of the 212A6 versus 212A7 removability discussion and holding on the en banc court. But, it arises out of the Northern Mariana Islands, the CNMI, which is a U.S. territory, and it's just so weird and how it could get to this point. But essentially, immigration law starts affecting CNMI in 2009 because that's what Congress decided. But before that, it was a U.S. territory. It still is a U.S. territory. Before that, it had its own immigration law bit, which allowed for some guest worker type program, and that's who Ms. Torres was. And Congress realized that this is not going to be fair. If we start implementing U.S. law, then all these people who are there under CNMI law, they're going to be present without admission or parole under U.S. immigration law 212A6. And so the Congress wrote in that these people like Ms. Torres could not be removed under 212A6 for 2 years. I believe it had a 2-year limit, but certainly had a 2-year limit at a minimum. And so it looks, reading the en banc case, that ICE just turned around and started trying to deport these people under 212A7 instead. And I just don't get it. I don't know what I'm missing, but it seems like Congress was very clear, and that I don't know why ICE would want to use a technicality when it was clear that the point was for Congress to throw these people a bone who, like Ms. Torres, had lived there for over a decade and who were just the subject of a change in law. I just don't get it. ICE, DOJ, I've been part of DOJ. These are government agencies who are supposed to do justice. So I don't know much more about ICE's decision in this case other than from this en banc decision. I just don't get it. I don't know who made that decision or why they did. But I'm glad that the Ninth Circuit said you can't do it.
Yeah. So we'll see. It goes to the Supreme Court. So I can't see the Supreme Court taking on all these cases. So if we have so many of them, inevitably a lot of them are just going to sit because, this whole Wolf situation probably is going to end up going to the Supreme Court.
That's a big one.
And it can happen fast because they got to make a decision on this. So they can't just let it sit. So I would imagine the Circuit Court is going to have to hear it quickly, especially because in that decision, Supreme Court said we got to stop doing these nationwide injunctions. They want to stop that.
There are votes for that.
Yeah.
Would your listeners hate me if I called him a wolf in secretary's clothing after this? Is that too? I'm not even a dad. That's a pretty dad joke. But one day I hope to be a dad where I can make those jokes.
Hopefully soon. Yeah, thank you so much for coming on. I'll try to get this out as soon as possible so members and everyone in the public could hear it. And I'm glad to have you on. I'm glad to have someone who likes talking about this as much as I do. And so
I love it.
Fun discussion.
Thanks, John. I'll see you next month.
For sure. Have a good night.
Bye, John.
Thank you for listening to this episode. For previous episodes and more, please visit the podcast page of our website, immigrationlawyerstoolbox.com. You can also visit the Toolbox YouTube and LinkedIn pages to catch the video versions of these podcasts, news updates, and a lot more. Immigration lawyers can also contact me to join the private Facebook page. The email is info@immigrationlawyerstoolbox.com.